Hello, good night. Welcome to Legalize this 13th day of October. Those among us who are old enough can point to some building in the town of St. George's or in Grenville or in Guelph or St. Helens of Victoria, which once housed a fledgling business, but which today is an abandoned building, the business being no more. Or you can remember houses in the village where vibrant families once lived, but which are presently abandoned. You may also remember some well-to-do family while growing up, but now you see the children or grandchildren of that family catching hell. Or you may also recall lands which were once well cultivated but are now abandoned in high woods, in some cases squatted upon. Or you may know of situations where people worked hard to send their children to school, including the university, but in their old age, they are now abandoned without care, oftentimes sent off the homes. You may also know of situations where a wealthy person falls ill and suddenly long absent family members descend and a fight breaks out for custody. These situations are not confined to Grenada. The same can be found in St. Vincent and the Grenadines, where the legal framework is very similar to Grenada, and they can be found in other Caribbean islands to varying degrees. Based on anecdotal evidence, I am of the impression that they occur less among Caribbean people in the diaspora. I've discovered through my research that in many cases, the problem has to do with the fact that the families who own these properties referred to above worked hard, very hard, sucked salt, as we say in Grenada, to build up these properties, but they did not pay attention as to what would happen to these properties when they are no longer around. There are also cases where children involved are not adult children, but minor children, as in a case where a parent dies young. These situations create their own difficulties, but they do happen. Tonight we have attorneys at law, Ruggles, Ferguson, Casey, and Sherrine Francis-Hackett to put these issues under legal eyes. But before we go on to our guests, I just want to thank those who are enabling us to bring this program, Jail Professional Solutions, JEM FM, carrying this program out of Canada, and Grenada Technical and Allied Workers Union.
Attention all workers, your health and safety at work are critical. At Grenada Technical and Allied Workers Union, we are dedicated to ensuring you have a safe and secure work environment. If you encounter unsafe conditions or are involved in an accident, take immediate actions. Report it to the company, your shop steward, and make sure it reaches your union. Your health and safety is a priority, and a strong union means a strong voice for your rights. Don't wait. Address concerns right away and protect your well-being. For a safer workplace and a better quality of life, stand with the Grenada Technical and Allied Workers Union. Together, we can create a safer, healthier work environment for everyone.
Good night. Sherrine, good night. Ladies first. Good night.
A pleasant good evening, Mr. Layne. Can you hear me clearly?
Yes, we're hearing you now.
Great, perfect. And a pleasant good evening as well to your listeners via social media, all the social media platforms. And a pleasant good evening to Mr. Ruggles Casey. It's a pleasure being on the program this evening.
Yes.
Good night, Drugs.
Yes. Hi. Good night. Good night. And a pleasant good evening to all listeners and viewers of the program, and to my colleague Sherrine. Also, another very interesting topic on the platform tonight.
Yes, because it happens every day, uh, and it happens too regularly. Uh, so I don't know, Ruggs, if we can start with you. If you can, you know, we have a discussion on this and point to some of the tools which can be used to deal with, address some of these situations and your own experience as a lawyer over the years in terms of
Yes.
dealing with it.
Yes. Well, first and foremost, the people during their lifetime are not into planning much for after they have passed on. Many people feel that when you make wills, that you feel you're about to die, and many make wills when, as the saying goes, flour, mud, and water, and they reach a situation where they believe one way or another that they are going on, passing on. But just to put things into perspective, in law, there are two ways to die. You either die testate, and testate means dying with a will, or you die intestate, meaning without a will. As the song says, there's a song that says a million ways to die, choose one. Well, when it comes to succession and property, the question always is, did the person die with a will or die testate, or did the person die without a will, intestate? If you die with a will, then that will says to whom your property should go after you die. It makes clear to whom the property should go. And under the will, a properly made will, the testator or the person making the will usually appoints an executor under that will. And the executor is the person who will be in charge of the property when the person passes on. The executor eventually becomes a legal personal representative of the deceased, stepping into that person's shoes and being
Yeah.
able to do what that person would have been able to do had he or she been alive. So that's with.
The first question is
Mhm.
whether the person making the will needs the consent of someone to appoint them as the executor.
Well, no, there is no hard and fast rule on that consent to appointment, but it is best if you seek, well, the consent of the person before that person is appointed. If the person is appointed without consent, it does not invalidate the appointment, but it's the proper thing to do, because it's a heavy it can be a heavy responsibility if you are appointed an executor, and many people who are appointed executors don't know what to do after the person dies. There might be issues of taking care of the funeral, for example, making the funeral arrangements, but beyond that, if you don't consult a lawyer, or if the person is not legally trained, then you might have some issues where the executor just sits there and nothing happens. And that executor comes and dies, and then you have issues.
This is
So,
my second question. If there are any special qualifications for someone to be an executor?
well, legally, there are no particular qualifications, but from a very practical standpoint, that person should be one whom you can rely on. That person should be one who you believe would be willing and able, very importantly, willing and able after you have passed on to take charge of your estate. And when I speak of estate here, estate means anything you own after you die. It doesn't mean an estate, a land, a whole big piece of land. Estate means anything you own, whether in terms of personal property or real property like land and buildings or bank accounts. Personal property would be bank accounts, vehicles, equipment, and so. So, when you are choosing an executor, you must choose one who is able to perform the task. Not somebody who, for example, may be elderly and may not be able to take on the task after you have passed on. But in terms of the criteria, legal criteria, which says you can only appoint an executor if they have 1, 2, 3, 4, 5 qualities, then that is not a requirement of the law. Yes.
Okay.
So,
sorry, go ahead.
sorry. No, I was saying that is for the testate side. So when you die testate with a will, your will says what should happen to your property after your death. You have left certain directions as to what should happen. Now, but many people don't make wills. They don't make wills, and then they pass on. The question is, what then happens? And when you die without a will, you are said to have died intestate. So testate for the will, intestate without a will. And the law then determines what should happen to your property. So with the will, you determine by way of the will what happens to your property. If you do not leave a will, the law determines what happens to your property. And that law is what is called the Intestate Estates Act, which sets out the order of priority as to who should receive or inherit your property after you die. And then similarly, somebody who is entitled under the law can apply for letters of administration to be the administrator or person in charge of your property after you have passed on. And so
you mentioned in the all that you said about a valid will, because you said if you make a valid will, and I don't know if Sherrine, you can come in here now, if there are special requirements for the making of a valid will. Because sometimes I know sometimes somebody make more than one will and they have the battle of the wills in the court.
yes.
I think it's important to pinpoint that to begin with, a will takes effect on death. And I often get the question, especially from the elderly folks. They made one will at X point in time, whether or not they can change their will. Well, the truth is that you can change your will every Monday morning. You do not have to go by a lawyer if you do not desire to do that. However, it is advisable because of certain technicalities. In terms of the validity, to begin with, you must be of sound mind. Yes. What is... Sorry, are you hearing me?
Yeah,
Yes.
but we have some technical issues.
Okay, my apologies. I was getting a little feedback. You must be of sound mind. Of course, you must be 18. It's very
You must be
important.
what? You said you must be of sound
18.
mind.
You must be an adult.
You must be an adult, yes.
Yes. Sorry, I'm getting a feedback. It is very important that when leaving property, the person who witnessed the will must not be a beneficiary of any property that you're going to leave.
But would that make the will not valid? If you leave a house or a piece of land for somebody and that person is a witness to the will, will that make the will invalid?
But it is not advisable that you leave property for someone and that person witnessed the will for several practical reasons. So, for example, you do not want me to know that I'm the beneficiary of your estate. It's important that I not be the beneficiary of your estate. I cannot be the beneficiary under your will and still be a witness to your will. Yes?
Right. But the will would still be valid. Even all that would mean is that what you leave for the person who signed the will.
The gift wouldn't pass.
Yes,
but the will itself would be valid.
That will fall down, yeah?
Yes, and for very practical reasons. I mean, it may sound.
But let me ask, as you raise that, is there any requirement that the witness to the will has to read the will?
Yes, there is a requirement under the Act. The person signing the will, the will must be read in their presence. Two persons must sign as witnessing the will, and it must be read to them. Both of them must sign at the same time, and the will must be read to them. I hope I've answered your question.
Yes, I think there may be issues as to the privacy of the will, whether in fact there's a requirement for the will to be read. I know in cases where people are, for example, illiterate, or if they can't see, then you have to read, you have to say the will was read to that person so that they understood. The witness is actually reading and be actually reading the will, or you reading it to them and they being aware of the contents of the will. I don't know, Mr. Ferguson, if you could just clear us up on that.
Yes. The signing, as Sherrine indicated, I think there is a requirement for the testator to sign in the presence of two witnesses, sign or acknowledge his signature, and then the two witnesses sign in the presence of the testator, one, and in the presence of each other. The reading of the will comes in special circumstances. To the best of my knowledge, it's not a general requirement, but let's say somebody cannot read and write and is making an X, saying this is my will, because you are permitted to make an X, preferably before a registrar. So because you are unable to read, then the will is read to you. That is as testator, or if you are blind and therefore have to make a mark. But as a general requirement for the reading of the will to witnesses, I think what is more important, as well Sherrine pointed out, is the signatures, is the signing, the acknowledgement of the signature, or the actually seen that it is signed by the testator.
I guess we'll say the best practice is that the testator actually signs in front of these two witnesses.
Right, yes.
The witnesses sign, they must sign in front of the testator.
Mm-hmm.
The best practices are decided in the presence of each other.
Yes. Yes. Certainly.
Yeah, because I raise that because when you have the battle of wills, as often happen, and I know, Ruggs, that you have had several cases where there is more than one will, and then these issues could prove to be decisive as to whether all what we refer to as the formalities for making a valid will were in fact complied with,
Mm-hmm.
because a case could turn on that, and
Yeah.
hence the importance of really complying with all of those. Of course, if you read the will to the witnesses, it doesn't affect the validity of the will. But
No,
as
no.
you see, the important thing is in terms of the signing of the wills.
Yes.
And when we said she said soft mind, what is soft mind? It must be of soft mind. I mean,
Yeah.
most
In
times
other
we
words,
know somebody
yes.
is of soft mind.
Yes.
But
That
the
you
other
have the
time,
mental capacity, to understand what you are doing. And
and
then
to be
again,
aware.
that comes back to the whole issue as to when a will is made, because you may have situations where people don't make a will, and they may go into hospital, and then they make the will under those circumstances, especially somebody who is elderly. Then what you want to do when a will is made is to avoid as many challenges as possible, because usually there will be people who are not satisfied with the provisions of the will, as a result of which they will seek to challenge um, uh, the will itself. And one of the regular bases for challenge is the absence of mental capacity at the time, or duress, undue pressure being brought to bear because the person was ill at the time, recuperating, or the person was beginning to have memory issues. Now, you can have memory issues and still make a will, but of course, it opens up the possibilities for challenge on that basis. But mental capacity is simply having the mental capacity, or understanding that you know what you are doing.
Mhm.
That's basically what it comes down to.
No,
Somebody who makes a will must know what he is doing, must know the gifts that he is given, and must intend to give those particular gifts.
no, you often hear sometimes when people challenge wills, whether in the court or it may not even be in the court, they may say something as, well, Daddy would have never done that if he had the right mind. Meaning that, listen, I expected I expected Daddy to leave the house for me. He didn't leave the house for me, instead he left it for somebody else. And you hear that, listen, Daddy would have never do that if he was in the right mind when he made the will. Is there a requirement in terms of sound mind that the person must at least know uh, who are the people or persons who reasonably will be expected to benefit from their will? In other words, I put it this way: if somebody makes a will, yeah, they have 5 children, they were very close to those children, but the will turns up now, nothing is left for those children, but it is left to, let's say, the gardener, or it is
Mhm.
left to somebody who is not known to the family. And there are issues as to whether the person had the right mind. Would that be relevant to the issue as to whether they were in fact of sound mind when that will was made?
Mhm. Yes, well, it certainly it certainly will be. But I think the starting point is that in Grenada, there is what you call freedom of testamentary disposition. It's a bigger worded concept, which simply means you can leave whatever you own to whomsoever you wish to leave it. You do not have to leave it to those who people may expect you to leave it to, because you have that freedom of testamentary disposition. Not all countries have that similar provision. There may be restrictions on as far as giving outside of the family is concerned. So you can technically do it. However, if, for example, there is an expectation based on everything that one would have left it for X or Y, but instead one leaves it for A, then what that may trigger is really suspicious circumstances that will lead to further investigation as to the circumstances under the will, under which the will was made. And especially when you have a situation where the person is elderly, it's an elderly person, and that person may have been sick, whatever the illness may be, and in particular, if there are allegations that that person has memory issues, then a combination of these factors, it would be a matter of evidence at the end of the day. So technically, the person can do it. Leave it to whomsoever he or she wishes to do. But when it comes to elderly people, that may trigger certain suspicious circumstances that would be in the mix. That's why it is so important, and Sherrine made the point earlier at the start. Anybody can make a will, but there are certain technicalities that you must provide for to make that will as challenge-proof as possible. Because the will only takes effect after the person dies. The person dies, now that person is not there to speak. So you speak based on the will itself. And when it's elderly people, and I suppose you'll come to that at some stage, the importance, for example, of having a medical certificate of fitness, that person understands what he or she is doing.
But as you raise the point, and Sherrine made the important point that you can change your will every Monday morning if you so desire. Because you often hear people say, well, look, the earlier will was made and this was left for, this is what the earlier will said, yeah, but then a different will turn up after the person died. How relevant will such a circumstance be?
Okay, that's me.
Yes.
Yes. Okay. The relevant will always is the last will. So if the testator decides to go, as Sherrine describes it, every Monday morning to make a new will, then the relevant will be the will made the last Monday morning before he or she passes on. Okay. So you could have 10 wills. What is important is which was the last will. Now, the relevance of prior wills may come in when there are suspicious circumstances regarding the making of the will. So somebody in the 9 wills had particular provisions for particular people, and then in the 10th will departs radically from those prior wills. That may be the basis of raising suspicious circumstances. And then, but it's suspicious, but you have to take all the factors into consideration, including issues of mental capacity, age, the circumstances under which the will was made. And really that's again brings one to the importance of addressing these issues as early as possible and not waiting, especially for folks, for example, who may have several children of different mothers. And so you have, all these different children. And or you may simply wish to leave it for someone specifically. At times, and it's always experience. Sometimes the specific people that the testator, and when I say testator, the person making the will, wishes to leave the property for, the specific people who don't get it simply because there was an error. There is an error with going about a particular the making of the will, the execution of the will. It ends up as being invalid, and that person died intestate. Yes.
Okay. Someone is asking a question here. If someone does not accept appointment as an executor, what happens?
No, but if someone, and it depends on what stage. So if it's a stage that the testator is making the will,
right?
Testator if male, testatrix if female.
I think then after the person died.
After the person dies,
sorry.
Yes. Then what happens is that somebody else who is a beneficiary of the will can apply for what is called letters of administration with the will annex. Okay. If an executor is appointed and that executor is applying, then what that executor is applying for is letters probate, the probate of the will, or proving the validity of the will before the court. Say, this is a valid will. I was appointed executor. I want you to issue me letters probate. So you call that probate of the will. If that person now says, listen, I don't want to take that responsibility, then somebody else who is a beneficiary under the will can apply for letters of administration with the will annex.
Okay, so far we have been discussing, Ruggles and Sherrine, what happens after someone dies, what happens to their property. But I want us to also look at what could happen, what protective, some problem, somebody saying they're not hearing you clearly, Ruggles.
Who, me? Oh, sorry.
Somebody is saying that.
Yeah, I'm not too sure. Yes. But are you all hearing me clearly?
I'm hearing you clearly.
Yeah, and Sherrine, you hearing me clearly too?
Yes, I'm hearing you. I'm hearing you very clearly.
Okay.
If I may, Mr. Layne, if I may.
If I know. Yes, sorry. Go on, Sherrine.
Yes. Mr. Ferguson Casey, who is quite my senior. I don't know if he has that difficulty, but if I may, permit me to say this. While it is very good to have a will, and it's advisable to have a will, I must say my experience at the bar in recent times, in terms of how long, and I know you have a very wide reach in terms of listenership of this podcast. The length of time that it takes to obtain a grant of probate in Grenada under these present circumstances, or letters of
Sherrine, we don't hear you clear.
Yes. Yes. It's coming very distorted.
Ruggles, someone is Try to correct it, Sherrine, and we come back to you.
Yeah.
So yeah, I said, but the program tonight, I want us to not only focus on what happens to the property after somebody passes, but also to measures that can be put in place to protect persons when they are vulnerable to becoming elderly. Yeah, the challenges that elderly people face. Because somebody here sends a question or gets something on WhatsApp. Good evening, all. And it says, if someone at the age of 88 shows up in a lawyer's office with the buyer of a property, with somebody who is seeking to buy a property, and at the time they have several children living children, with an arrangement is made that the buyer will own the property after death. And the question is if there are any checks that should be made by the lawyer. I take it to mean, I think the question is saying somebody 88 years old, elderly person turns up in the office with somebody to say, listen, somebody wants to buy your property. Yeah? If there are any checks that should raise a flag to the lawyer and prompt any particular checks and what you may want to say diligence by the lawyer. I don't know if it's a real situation, but the person just said, I said this.
Yes. Well, what you do first and foremost is to ask the relevant questions. Because when a client comes to see you, at the end of the day, you don't just automatically do what the client wants, because what the client wants may not necessarily be in the client's best interest. And you must advise accordingly. Of course, it's the client's matter, it's the client's land. And therefore, if those are the instructions, then you must be clear that that is what he or she wants to do. So the first point is that it will only take effect upon death, as Sherrine pointed out earlier. So that will, apart from it can be changed during the lifetime of the testator or the person making the will. The other important point is that the testator is free to do whatever he or she so wishes before he or she dies with that property. So, for example, there might have been a will made in 2020 saying, I leave my property in Granance to X. And the testator walked in, the same 88-year-old man walks in tomorrow morning and says, I want to sell my Granance property. He's entitled to sell the Granance property because he's not bound by what is in the will. He's free to sell it or dispose of it as he or she so wishes. But what you may wish to do is to raise the relevant questions and ascertain whether that is what he or she wishes to do. So, for example, if he makes a will, he must know that, listen, the person who is the beneficiary under the will not get it because you are selling it to somebody else. So it's important to clear all of these issues, but it comes back to that point you made earlier, which is in terms of not just post-death, but what elderly persons may be able to do or should do to ensure that what happens in their later years, that they are comfortable when they are no longer able to work. And that brings me, and I'm sure you probably have it on the agenda, the program tonight. But like deeds of gift. So, for example, you can dispose of a property either by will, which takes effect after your death, or you can dispose of that property during your lifetime. The technical description of it is what is called an inter vivos disposition. One is a testamentary disposition, the other one called an inter vivos disposition, disposed of during your lifetime. So what happens now is that frequently my children might want security to raise loans, and it's more convenient if they have property in their name. For whatever reason, the person decides, listen, I'm going to give X the property. And you give that person, you give X the property. So you don't wait until you pass on, or you don't necessarily leave it in a will, or you may have it in a will and then decide, listen, I'm going to give X the property now. And then now, a year after, X decides, well, I want you out of the property. Right? I want you out of the property. That's a real scenario at times that people unfortunately face, believe it or not.
So
Where then
let me just get it clear. That you decide during your lifetime, you are giving your property to, let's say, your son, your daughter, whoever it is. Yeah? And you're saying, if you do that, there is the risk that the person now being the owner of the property can decide to put you out of the property.
Right. I'm saying that is possible, and that has happened. That has actually happened. So one has to think about protective measures, and I'm not in any way saying it shouldn't happen. There may be circumstances where it's best to happen. It's best that it happens that way. It's beneficial for the person giving it also, but it is important. And that's where the professional advice comes in. Lawyer client, the protection that is given to that person, what kind of protective measures can be given so that you achieve the best of both worlds. And in case of a deed of gift, the retention of a life interest is always advisable. So you have the retention of a life interest, nobody could put you out of the property because you have a life interest in the property. But you have had many situations where children have sought to put out parents because a gift is a gift. You can't argue that because it's a deed of gift, somehow you can't put me out. You have transferred the legal title in your property to someone else. That person becomes the new owner, and that person can do whatsoever he or she wishes to do with the property, including put you out. Unfortunate as that may be.
Right. So that answers the question here. What happens when someone makes a will and then the property is makes a will, leaving a property to someone, and then the property is passed on as a deed of gift? Which one would be determined to be valid? And of course, the answer would be the deed of gift if it is valid, because the will only takes effect on your death.
Upon death, yes.
Let me just go back to the WhatsApp question though, because I think what the person is saying, someone is 88 years old, yeah, and they turn up in your office together with someone who wants to buy their property, yeah. So they turn up with a purchaser. And the arrangement, however, apparently saying the arrangement is that, well, it looks as though there will be a life interest, but the sale and the freehold in the property only passes after the person dies. And the question is, in a situation as that, whether that should put the lawyer on inquiry and prompt the action of certain questions, take certain measures as the case may be. I think one of the things that jumps out there is the issue of independent legal advice.
Mm.
I think that's one of the things I'm gathering from that.
Yes. Independent legal advice for the vendor, the person, for the 88-year-old person. However, based on that example you're giving there, this is not a gift. If you're talking about a purchaser,
no, this is not a
then
gift.
that purchaser needs to be advised also, because you don't know. That purchaser also has to be properly advised, because it's a most unusual sale. You don't know if that person, the vendor, will outlive you. And then what a sale of land is all about the transfer of legal title from the current owner to the new owner, who either pays for the property or get the property as a gift or inherits the property. So it's a transfer of legal title. And then it depends on what the purchaser wants to do to. It's an arrangement that you don't know. Is the happening of a certain event that is uncertain. To go into that arrangement, that is a fickle arrangement.
What I get is that sale subject to life interest. It's a
sale subject.
Subject to life interest.
Right.
So you're selling the property for the person, but you reserve a life interest. And the question is whether the 88-year-old person is deserving of independent legal advice in those circumstances.
Well, sure. From that standpoint, the person would be deserving of legal advice. But it's different to, even with the life interest, I'm saying, with the purchaser has to be properly advised, because it depends on what the purchaser is looking to do with the property. All those factors, as opposed to a family member, where the family member might be just living in the property. At times people purchase land. There are restrictions on the use of the land, especially if there's a life interest, or there might be covenants associated with the land, that the purchaser has to know what is possible and what is not possible if you purchase the land and there is a life interest associated with it. That's quite different from you passing it to your son or daughter or some close family member and retaining a life interest to live in the house. There's no financial consideration passing in the latter example. But I think the point has been made.
And someone is asking whether a deed of gift is irrevocable.
Yes. I know, Sherrine, you want to
Sherrine, you wanted them sister come in?
Mm-hmm.
Hello, Sherrine?
Is Sherrine back up?
Can you hear me clearly now?
Yes, I'm hearing you. I'm hearing you.
Well, I don't think your video is working. Are we not?
Well, my apologies.
I'm seeing her.
I'm hearing everyone clearly.
Yes.
You're not seeing me. Is it a case where you're not seeing me?
Yes, say what you have to say. Wait, what you are saying.
Mm-hmm.
Go ahead, Sherrine.
Yes, so you were asking, a question concerning a deed of gift.
Yes, the person was asking whether a deed of gift.
Well, it's very important. Yes, it's very important when you're doing a deed of gift. First of all, you can't. It is important that, well, it's not necessary, but I generally check the title to make sure that the person doing the deed of gift actually owns the property. It's not necessary, but it's, in my mind, prudent to check for title, because, you know, from time to time, persons would come to your practice, they want to give X or Y property, and lo and behold, the person doesn't even own the property. And in that case, you cannot give what you don't have. But there will be, you will have to go to court to make an application if there is a deed of gift and it is deemed to be invalid. You would have to go to the court to make an application outlining under what circumstances that you would like that deed of gift to be revoked.
Okay, so it's revocable on the order of the courts.
It is.
So you can't give it, you can't give somebody today and say tomorrow, say, look, I changed my mind, I take it back my property.
Absolutely not.
Right, but if after you want to say when the person tricked you or something, so you have to go to court to have it set aside.
If a situation arises, you will have to show some special circumstances to the court by way of application to the court.
Yeah. I don't know if either of you, if we can speak about the usefulness of powers of attorney in terms of protecting the interests of elderly persons and having that as part of a plan to protect your interests when if you realize you're going down. The use of power of attorney, giving powers to somebody to do certain things on your carrying certain transactions for you.
Well, if I may, a power of attorney can be general, it can be specific. Of course, specific to a particular transaction or so you want carried out, or general. So normally the attorney would take instructions from the client in terms of the purpose of the power.
The attorney, they know you mean the attorney at law.
Yes, the attorney at law
will take instructions from the client
in relation to the purpose of the power of attorney, whether it is to sell a particular parcel of land and to sign on behalf of the vendor and have the money deposited into account. So powers of attorney can be very specific or it can be general. It is a power of attorney ends if the person dies. Yes. And it is in our jurisdiction, it is made by deed, because I have seen other forms of powers of attorneys made in other jurisdictions, and persons think it can be used in Grenada. However, our power of attorney here must be done by deed and recorded in the registry. So a letter saying that you can do X and Y is not a power of attorney.
Right. And the power of attorney there, just to go back to clarify, is giving someone else the power to carry out certain transactions on your behalf. That is general to say that they could do anything on your behalf, or you may just want to limit it to say to sell a piece of land, to put the money in the bank, to access my bank account, as the case may be.
Yes, and so it is very important, especially where elderly persons are concerned. It is very important that they understand the effect of a power of attorney, because you do not want a situation where you give certain powers of attorney, and that person, for example, can withdraw monies from your bank account, and lo and behold, one day you realize that all your monies have been withdrawn. So you have to be very prudent when it comes to giving any particular individual power of attorney into your affairs, especially if you're elderly. Yes, so that's very important that you understand the effect of a power of attorney, and you understand the scope of the powers that you're giving to the attorney.
Because I have seen situations where people are They give the power of attorney. They have a power of attorney out there for somebody to, for example, to sell the land. Yeah? And it may be years later the land is sold, and then they turn around and say, well, I did not agree to that sale, I wasn't consulted on the sale, as the case may be. So it's important for them to understand if you give a power of attorney to do something and the person exercise the power of attorney, then it is valid. That's what we say. Somebody's asking
if I may too. If I may, in general, when it comes to powers of attorney and will and deed of gift and so on, it's very important that the attorney have one-on-one with the client, because I've heard of situations where children walk into lawyers' offices and say, "Mommy sick," or "Mommy want to give me that piece of property," or "Mommy would like me to, to have power of attorney." And we have to be very mindful and very careful that the elderly, especially, they're not taken advantage of and just simply saying yes because they're in the presence of their children, or, for example, somebody who takes care of them and they probably feel that they have to agree. So as you mentioned before, independent legal advice is very important, and sometimes simply talking to the client alone, to the exclusion of everybody else, to really find out, reading their words and their facial expression, to dig deeper to see if that person really wants to do a power of attorney or whatever the case.
Ruggles, you wanted to come in?
Yes, well, I generally agree with the points expressed, unless you want some elaboration. But the when you are living, then it's if you are unable to do certain things by reason of age or your physical ability to do it, then the best alternative will be to appoint a power of attorney. The issue as to the extent of the power that you give to an individual, as Sherrine explained, is a specific power, or you can just give a general power. And a general power means that that person can do anything that you can do. It's not restricted, including the sale of property. And usually, which goes to the point that you made last, in that power of attorney, the principal, the person who is given the power, usually states, I hereby ratify the acts done by my agent. So even up front in that document, you are ratifying or agreeing to the acts. So again, it's important, whoever you're giving the power of attorney to, then that person must be a trustworthy individual, and you must know the limits you can go, whether you do it just in terms of your general care and well-being, or you give it unrestricted. And I think sometimes the challenges arise when the power is unrestricted and you have ratified it, because you can't just like you can't come back and say, well, I give a deed, I won back my land. Yeah, you have already given it. Is a gift. You have had circumstances where, especially if there are many children involved, and a deed of gift is given to one because that one happens to be treating you good at the point in time when the gift is given. Then you have to understand, if later on the person then treat you bad. And I'm using this from actually specific examples, real examples you have come across, and you say, well, listen, that man started to treat me so bad, I want back my land. It does not operate so. You have already conveyed and given title to that person unless it has conditions attached. There are conditions attached to it. But generally, you can't give and then take back. Just as with the power of attorney, you can't give a power and then something that suits you, you say, well, listen, I ratify that, I agreed with that. But something you might fall out over later on, then you say, well, listen, I didn't authorize that. You have the power of attorney is the document of authorization.
Okay, Rob, just hold a point because I just want us to recognize those who sponsor this program. Jail Professional Solutions, JMFM, carried the program out of Canada, and Grenada Technical and Allied Workers Union, G-Town.
Attention all workers, your health and safety at work are critical. At Grenada Technical and Allied Workers Union, we are dedicated to ensuring you have a safe and secure work environment. If you encounter unsafe conditions or are involved in an accident, take immediate actions. Report it to the company, your shop steward, and make sure it reaches your union. Your health and safety is a priority, and a strong union means a strong voice for your rights. Don't wait. Address concerns right away and protect your well-being. For a safer workplace and a better quality of life, stand with the Grenada Technical and Allied Workers Union. Together, we can create a safer, healthier work environment for everyone.
Okay, so we have a question here. What's the difference between a deed of gift and a will? Further, can a deed of gift be challenged by a family member or relative? I think we went through that. A deed of gift passes immediately upon delivery of the deed. The will only takes effect on the deathbed.
Yeah.
And the answer is yes. You can challenge a deed of gift, but you have to go to court.
Yes. Yes.
Someone is also asking Ruggs, if you're part owner of a property, both Ruggs and Sherrine, if you're a part owner of a property, can you give your share to someone if you so desire?
If you are part owner, yes. Yes, you can give whatever you can give, whatever your interest is. You can't give beyond the extent of your interest. So if you have a half share, you can attempt to convey the whole property. You must convey whatever your interest is. So, for example, the parties, you might have two people owning properties as tenants in common, which is another important concept in a discussion like this, the concept of tenants in common and joint tenancy, where more than one individual owns a single property. So you have two or more people owning property. So when you have it's owned as tenants in common, then the respective owners own shares, usually in equal shares. So two people own a property as tenants in common in equal share. One has a 50% interest, the other has a 50% interest. If you have to convey that interest, give a gift, you can pass only the extent of your interest. Yes, so I think that basically answers that. However, if it's a joint tenancy, you own it as joint tenants, then joint tenants own the whole. There is no share. And so let's say A and B owns land as tenants in common in equal shares. A dies and B is the survivor of the two. Then A possibly could have made a will conveying his 50% to an individual or individuals, or if he didn't make a will, then the law of intestacy will apply to his 50% share. However, if it is owned as joint tenants, It means both parties own the whole. There is no share. And therefore, when A dies, B continues to own the whole. It does not go on, unlike a tenants in common, it does
They
not
can
go
pass their share by
on.
will.
You can't pass the share by will.
But presumably, okay, when we stop at that there on that point. There is some book Alan Oliver said the current issue with William Oliver's last will, I don't know who's William Oliver, is that he did not write or sign a will. Sadly, the lawyers who filed for letters of administration with the
Yes, probably when these examples maybe we could just refer to as X, because we should avoid calling
yeah,
names as
yes,
far
yes,
as possible. Yes.
yeah. But
Mhm.
it's a public document. He said that there was an application, will annex on behalf of his son, who is known fraudster, clearly knew that the will was a fraud. I have been releasing when they issue. That's an issue for the court as to whether the will is valid or not. I don't think a
Yes.
lawyer could determine it. That's a issue for the court. I would
Mhm.
say if you are aggrieved by whatever it is, you get a lawyer and you make
And you challenge it
appropriate application.
accordingly.
Yeah. Okay.
Yes. Yes.
If I
Sorry. Go ahead, Sherrine.
I just wanted to follow up from where Mr. Ferguson left as he introduced the concept of joint tenants and tenants in common. In terms of, in the context of married couples who may have children from previous relationships, that is something they may want to discuss when they're buying property together. Discuss with the lawyer whether they want to hold the property as joint tenants or tenants in common, because you may have a situation where one party may have children from a prior relationship or so and would like to give his or her share, yes, to those children. So it's very important in that context as well, in terms of married couple context, who may have children from previous relationships also. So that is something they would want to consider in terms of when they're holding property.
Okay, good. One thing I just want to go back to the power of attorney. The person who gave the power, the principal, as you call it, Ross, is he is anything that was done within the scope of the power is binding upon him or her.
Yes.
However, the question is, can a power of attorney be revoked?
Yes. And the short answer is yes.
Right.
In fact, the person who gives the power can revoke the power or take it back at any point in time. In fact, there are 2 points. There are 2 points that need to be raised here that sometimes create confusion. If A gives B power of attorney, it does not mean that B alone can then act. Like you have transferred all the power you have to B, and therefore the principal or the person given the power can't do anything because B now has the power. The principal always, A still retains the power to do anything that he has given B the power to do. So if, for example, a power of attorney is done and A says B now has a power of attorney to do 1, 2, 3, 4, 5, A still has the power to do 1, 2, 3, 4, 5. So that's the first point. And the second point, A, without consultation with B, even because sometimes some people are aggrieved by that, it's a question of courtesy and so, but A can revoke that power at any time. There and appoint somebody else or just revoke it simpliciter and decides to do everything for him or herself.
Okay. That takes me to the point of guardianship. I don't know if either of you want to just elaborate on the issue of guardianship and how guardianship differs from a power of attorney? When does guardianship kick in with regard to the protection of vulnerable people, in particular, included and in particular elderly people?
Okay. The guardianship, and that's an important distinction. A guardian is appointed by the court. So, for example, let's say somebody has mental challenges. That person does not have the capacity to make a power of attorney because, just like with wills, the person cannot appreciate and understand the document that he or she is doing. So, but of course, once you can understand, it might be a physical issue. You not being able to care for yourself, then you can make your power of attorney. Guardianship comes in generally when that person is unable or lacks the capacity to be able to take decisions and then wishes for somebody and somebody else steps in. The person may be the person who usually takes care of, let's say, X, but now you are taking care of X, but X doesn't have the capacity to access his or her bank accounts, for example. X does not have the capacity to sell his property, which may need to be sold to take care of that individual. So just as the court is the ultimate protector of children, just so the court is the ultimate protector of mental patients. And then you have to go to the court now, apply to the court to say, listen, this person does not have the capacity. You usually would require some medical evidence to support the position that the person does not have the capacity. And you need, therefore, in order to take care of that person, to access his or her bank accounts, maybe to sell certain property to be able to continue maintaining that person. So what happens is that the court will make an appropriate order which sets out the conditions or the power that you have, appoints you as guardian, and then will indicate the powers within the context of the application that you make, the powers that the guardian has, and it will also impose reporting requirements to come back to the court and indicate after a 3-month period, then what's the status? Because here you are talking about appointing somebody who can automatically access bank accounts and do things that the patient, as the person is usually referred to, is called, cannot do him or herself, and therefore cannot monitor what is happening. So the court then takes that position and would require you to report while you are a guardian.
And sometimes it could be a difficult issue for the court where you have dispute as to who should be appointed, because this person might say, I should be appointed. That person says, no, I should be appointed. Would it help in terms of, would it help if someone, when you are of your player mind, song mind, actually stated in some document or the other who you would wish to take care of you if you become incapable of taking care of yourself?
That certainly helps.
It helps, yes.
That certainly helps, because you are making a determination yourself.
Yeah.
And that takes care of issues of fights between
Mhm.
siblings and people who otherwise enjoyed a good relationship before. And that's one of the sad things about death. When the patriarch or the matriarch of the family goes, um, that in a sense was the glue holding everything together.
Was
And
advanced.
then you have, issues. As the saying goes, if you don't have is one thing, and if you have, it's quite another thing. It leads to all kinds of tension and friction. And
Mhm.
the more instructions you can leave in
Is it
those
better?
circumstances, it helps.
And in the case of just to go back to wills for a bit and sharing this one could be for you. In the case of young children, uh, a young person making a will, well, not necessarily a young person, but when young children are involved, it's going to indicate a guardian in the will, no? Who you would like to be the guardian of the children.
Yes, not just a guardian, but also especially and also a trustee. Um,
Okay.
so if you have a will, you definitely would like to name a trustee, and that's a very serious role. That's a very serious responsibilities. There are certain rules and obligations of trustees. And of course, you have to make, it's very important to make provisions for minor children,
Mhm.
especially in wills. In addition, we also have the Child Protection Act and Adoption Act as well.
Which hopefully we
So
will have a program on it in the future.
yes, so I don't want to get into that too much, but
Yeah.
an adopted child is also considered a
A
child.
child. Yes,
All right,
yes.
so we have to be very, when we are making wills, we also have to take that into consideration.
And they benefit if you don't make wills also. There's a question from
Yes.
Bob from there's a question here. This question is for Ida Attorney. Someone has a power of attorney in the UK. Does it extend to Grenada if the person who gave the power of attorney has property in Grenada?
Well, I don't know if I want to answer this question directly. I haven't seen the power of attorney that the person is referring to, but generally I have seen of attorney from the UK, and it differs from what our powers of attorney here in terms of we require power of attorney to be made by deed. So I'm not too sure. In this situation, I do not have access to the actual power of attorney that the person has, but I've seen powers of attorney from the UK, and it is not done by deed. I
Mhm.
don't know if Mr. Ferguson has seen others, but those that I've seen has not been done by deed, and so it cannot be used here.
Yes. Well, again, it depends on the nature of the power being conveyed and the importance. For example, if if they deal with matters touching and concerning land, you would need to have that power registered um, on the in Grenada for it really to take effect in Grenada. It will There is a requirement for registration. Um, and again, an important point too, which triggered by that particular question. Laws differ in different places, and even in the United States, where you have 50 plus states, there each state might have its own laws, and therefore, um, when you are making wills, for example, if you make the will abroad and that will, the law in the particular state you have made it does not comply or is not consistent or the same with our law, and then and you're attempting to dispose of property in Grenada by that will, which is valid where you make it, then that will is not a valid will under our law, because the jurisdiction or the authority has to be over the geographical space, Grenada, where the land is situated. So a lot depends on what is the nature of the power. But once it concerns something that is outside of the place where you made it, whether in the UK or elsewhere, then you would need to have that power. Once it touches and concerns land, then you may need to have the power recorded. The safest thing to do is to make a power in relation to that property in Grenada.
Yeah, and I think there's also a requirement that to record a deed in Grenada, it has to be prepared by an attorney authorized to license to practice in Grenada. So in terms
Yes.
of doing for land, and so that would be an issue. Somebody say, Mr. Host, this program is viewed all over the world. You may want to list their phones, cell numbers, I guess, meaning both you and Ms. Francis, for the benefit of persons who may want to contact them.
Well,
That's just
yes,
a comment.
yes. Well, generally, for me, it's a public education program. So
Yeah.
I would like to stick to the public education aspect of it. The numbers are public otherwise in terms of contacting. But because I'm always reluctant, because it's not, these things are done strictly for the purpose of public education, and therefore one is free. When I speak, one is free to speak to any attorney at all, on these particular issues.
And we just want to make the point, what we say here does not constitute legal advice on any specific issue.
No, it's really about empowering individuals, empowering people that they have the basic knowledge of the law, demystifying the law as best as possible. But it is always important when you have a particular legal problem to still speak to an attorney on the issue, because the factual situation may have certain unique twists that where you have particular legal principles applying. And just to repeat a point, for example, Sherrine made earlier, and it's something that folks, especially who do wills, because you can do your own will, or there are usually people in the community who do wills, prepare wills. But it's extremely important that they understand some of the niceties under the Wills Act. So, for example, if you are witness to the will, you can't be a beneficiary. The will would not be invalid by any stretch of the imagination, but you will lose your gift. Under
You are your spouse.
Yes, under that particular will. So all these, small points, but very significant,
Yeah.
and it makes a major difference after. Yes.
If
Yes.
I may just follow up on if I may just follow up and make one brief point, Mr. Layne.
Yes, go ahead.
Yes, I'm not sure either of us mentioned the residuary clause. It's just a big word, but if you think about it as the residue, should you have anything left that you didn't specifically mention in the will, who should benefit from it?
The leftovers.
And that is important, because if there is property that has not been mentioned or accounted for in the will, or property, of course, that you would have gotten later, after, sometime after you made the will, then you should have somebody to benefit from that, and there should be a residuary clause. So the residue, whatever is left, if you do not have someone to named as the beneficiary, then the property would go on
The person get the leftovers. And
Yes,
as I've heard somebody say, if you win the lotto the day before you die, it goes to that person.
that's correct.
Yes.
So I think it's important that you have
Sherry,
that.
you're making a point earlier about, I think you got interrupted. You're making a point earlier regarding the letters of administration.
Yes. So letters of administration, it may sound very funny and very jokey, but I once had a client ask me, when is he getting the letters, right? So letters of administration is not a letter. It's the name could be very misleading. It's actually a legal document, a grant that you get from the registry. So there are some little words that could be very misleading. For example, executrix, um, letters of administration. But the point that I was going to make earlier is this. A will takes effect after death. A deed of gift you can do in your lifetime. And I suspect tonight we're not getting into trust and all of that. There is a real situation where I've been, and yesterday was my 7th year, I believe, in practice. Yes. So we're approaching 10 years, where it takes, and I'm not bashing anyone, I'm not bashing the powers responsible, but it takes an exorbitant amount of time, it seems, lately, as much as a year, to obtain a grant from the registry. So without giving any general advice, I would say, yes, it's good to do a will, but obtaining a grant of probate or obtaining grant in letters of administration sometimes doesn't happen immediately upon your death. It depends on the workload of the registry, along with other factors, and it can take as much as a year or more. So as Mr. Ferguson case you would have mentioned, another option, instead of applying to the court for a grant and waiting 2-3 years or how many years it might take, another option can be, you're alive, you're in your right mind, you can give the property by way of gift and retain a life interest. The challenge for that with your children is that the children cannot take out a mortgage and do certain business without your consent. But do not think that you are going to die today, leave a will, and you're going to get a grant in the morning. It doesn't work like that.
The inland revenue, sorry. I was saying the inland revenue may say that there are certain tax implications also, which is always a consideration.
Yes.
Just one or two other things which are not strictly doesn't fall within the legal framework and such, but issues as life insurance, bank accounts, the use of standing orders, and so in order to manage your affairs, in particular for elderly people. We also mentioned with powers of attorney, actually making a provision in some document as to who you would like to take care of you if you cannot make certain decisions. Of course, the court has to appoint a guardian, but at least you can give an indication. Those issues. So I want to again before we end, just thank our sponsors, Jail Professional Solutions, JMFM, very reliable, carrying the program out from Canada on JMFM, and also Grenada Technical and Allied Workers Union.
Attention all workers, your health and safety at work are critical. At Grenada Technical and Allied Workers Union, we are dedicated to ensuring you have a safe and secure work environment. If you encounter unsafe conditions or are involved in an accident, take immediate actions. Report it to the company, your shop steward, and make sure it reaches your union. Your health and safety is a priority, and a strong union means a strong voice for your rights. Don't wait. Address concerns right away and protect your well-being. For a safer workplace and a better quality of life, stand with the Grenada Technical and Allied Workers Union. Together, we can create a safer, healthier work environment for everyone.
Okay, and Bob Marisho is saying that Tony Ferguson, I like the Latin description, inter vivos. Yes,
Yes.
inter vivos. I've not heard it in years. The very famous speaker of the upper house loved to use the term inter alia. So,
Okay.
I'm going to end, Sherrine, we can get your closing comments.
Yes, in closing, I think it's my first time on the program since the launch. I want to thank you for the invitation.
Okay, Rose?
Yes. Well, again, a very important program, and it's important that members of the public, you don't need any formal legal training. They are just basically certain issues that are important when you're planning, whether during your lifetime or for after you have passed on. And these very, very important points can be picked up on programs like these. That's why these programs, as I always say, serve to demystify the law and can make significant differences in the lives and the quality of lives of people. So, I just want to urge you to continue the great work, and continue to inform and educate on these important matters. Yes. So thank you for having me once again.
Thank you very much, Rose. Thank you, Sherrine. Thank you, JMFM, Tao. Thank you, Jill. Thank you to the administrator, Bentley. Thank you to all the viewers and listeners. Thank you to all those who posted comments, asked questions. Thank you very much. See you next week.